Welcome to part 5 of the Fire Department Ambulance Billing Series. My name is Brad Pinsky, and we are back with Pinsky Law Presents. And we're going to continue our series on ambulance billing now with billing fraud and compliance. These are things you've got to know because, as you will find out, billing has benefits, but billing has significant pitfalls that we need to be aware of. And so we'll talk about them here. Let's talk about the Health Insurance Portability Act, HIPAA, you call it HIPAA. For so many years, for some reason, fire departments have been advised by their attorneys that HIPAA applies to fire departments. And we have said forever it does not. And you've got to understand that HIPAA only applies to those entities who electronically bill for their services. And up until July 8th of 22, fire departments were prohibited from billing for ambulance services. Now, we take a little pride in the fact that we were finally proven right, despite everyone we were saying we were wrong. In 22, earlier in the year, in Erie County, a court agreed with us and ruled that HIPAA does not apply to fire departments because you don't bill for ambulance services. However, now you can bill for ambulance services. So what does that mean about HIPAA compliance? It means this: if you start billing for ambulance services, then you will be required to comply with HIPAA. And HIPAA is a lot to comply with. It's one of the things in Module 1 when we said, look, for $6,500, we'll do all these things for you. It's one of the things we will do for you. We'll provide you a HIPAA compliance manual. We'll provide you with the forms. We'll provide you with training. And we'll provide you with training videos as part of that package. Because if you start billing again, you must comply with HIPAA. And there is a lot to comply with. It's mostly a record-keeping and disclosure statute, but it comes with fines and penalties, so you need to be aware of it. So let's talk about more serious fines and penalties because, again, when you start billing, you better do it right. Otherwise, you could be charged criminally or civilly, either with a crime or with a civil lawsuit for money. You could be charged with fraud or fraudulent billing. And there are a lot of different fraud schemes that can lead to these convictions and these accusations. But look, you could be charged with insurance fraud, Medicare fraud, Medicaid fraud, mail fraud. If you mail any of these, and you will, if you mail bills, if you use a postage stamp for anything, now mail fraud comes into play. There are significantly huge fines and penalties in the millions of dollars that can be imposed if you are found guilty of a civil or criminal violation. In fact, the fines are not, hey, just pay back the money you should have gotten. The fines triple. We call them treble damages, but the fines triple as a disincentive for you to want to engage in fraud. And hopefully no one wants to engage in fraud. Look, you could go to jail for some of this. You could be barred from Medicare and Medicaid. I don't think anything's worse than jail, but nonetheless, the more likely outcome is being barred from Medicare and Medicaid. The criminal issue, you have to understand. The question that will be asked of a jury is, did the fire department, fire district, whoever, we'll talk about that, did you know or should you have known that fraud was occurring? And if the jury finds yes, you knew, then you may be convicted and may be subject to jail time or more likely, I'm not trying to scare you, but more likely significant fines and penalties. Now, let me talk to you about common billing fraud. First, there is the very common one of upcoding for false services. In other words, you are a basic life support and your billing company now increases you to advanced life support, right? Maybe you didn't do any ALS on scene, but and so you wrote the PCR as BLS, but now it gets upcoded to ALS. Why would a billing company do that to you? Well, a non-reputable billing company would do that because if they are working on a percentage, they get paid more. Or maybe you want that bill to be moved from BLS to ALS because you want to earn more. Doesn't matter the reason. If you do it, it's fraud. I've seen where mileage has been increased. Okay, we had a loaded mile 10, with the patient in back, we went 10 miles, and now I'm going to make it 20 miles. Who will ever know? Well, Medicare, Medicaid, the insurance companies, they'll know. If you bill for non-medically necessary services and you change the bill to make it look necessary, in a prior module, I gave you the example where, let's say we have a cut finger, but all of a sudden you're like, boy, you look like you're having difficulty breathing. Are you really having difficulty breathing? And they're like, oh yeah, maybe I am. Well, guess what? If you turn a cut finger, which does not need an ambulance or a hospital, and you turn that into difficulty breathing, you could be found liable for fraud, and that is the changing from the non-medically necessary to medically necessary services. Don't do that either. Well, what if you said that, hey, we had a paramedic on scene, he or she made a ALS evaluation of the patient, so we're going to bill more. No, paramedic was never on scene, you better not be doing that either. What about changing the medical condition from the PCR to the billing code that has a better reimbursement or a better chance at being paid or paid at a higher level? Yeah, don't do that either. Don't change the medical condition. That's kind of like what we talked about, changing non-medically necessary to medically necessary. Don't do that. What about you bill patients who were never patients? This has been done. This was pretty common, where employees suddenly were saying, oh yeah, I went to the hospital 6 times, or my aunt went to the hospital. Okay, she never went to the hospital, but we just bill her insurance company. Yeah, don't make up fake calls. Also, you could go to jail for that. Taking kickbacks in exchange for being awarded ambulance contracts. Now, I don't get into this a lot and didn't get into this at all really when we talked about waiving co-payments, but this is one of the possible allegations against you that, especially, let me give you a more common scenario. Let's say you're a fire department and you contract with the town, and let's say the town is going to bid this out, or they don't have to, but let's assume they're going to issue RFPs or bids, and they want to say, well, we want to look at our best options. Since you're going to bill anyway, let's see who can do it cheaper. And you say, listen, if you hire us, we will not collect the co-payments. We'll waive those co-payments, and so we'll only accept insurance only. Well, the problem is the law says that is a kickback, because what you're saying is, listen, town, we have a legal obligation to collect the co-payments, but we'll waive that. We'll circumvent that legal obligation if you will give us the contract. So what you're doing is you're bribing the town. That's illegal. You're also waiving co-payments, which may be illegal if not done properly, but just the offer to do that in violation of the law constitutes a federal felony. It's a kickback. What about if you said to doctors, hey, send everybody our way and we'll send you some money? That's also a kickback, right? You should not pay for referrals ever. In fact, never give anything of value for referrals. Bad idea. And I would tell you, the one you most commonly are going to find under this kind of law that we're kind of cockamamie law that we're operating under, where you're prohibited from providing services under even mutual aid or routine responses out of your service area as defined in your ambulance service certificate. If you routinely operate outside your ambulance service certificate, or you operate and you bill for services that state law prohibits you from billing, and that's why this gets really serious, you could be ordered to pay the money back. And let me repeat this, because even though it's last on the list, I think it is the most common likely scenario. New York state law, go back to modules 1 and 2, prohibit you from operating outside your ambulance service certificate area and billing for that, right? You can go, but you can't bill for it. If you bill for something that state law says you're not allowed to bill for, guess what? You're going to end up paying the money back. And not just dollar for dollar, $3 for every dollar. And if you keep doing it, at some point, a jury could conclude, you were doing this for a couple of years. You definitely knew it was illegal and you kept doing it anyway. Bad idea. Don't do that. We talked about soft billing and co-payments in the last module. but I want to just refer to it very quickly again. Soft billing and waiving copayments may be illegal because you are obligated by federal law to collect them. You have to do it the legal way. If the municipality would like to waive copayments, they can do that. If it's a municipality who's billing and it's a municipal ambulance service. Look, there were a lot of issues with this. This is way more complicated. I'm just throwing this out there to say this is one more thing that can get you into trouble. I'm not going to go further into this. It's in the prior modules. So please look at that, and you'll get a full discussion, many slides on this topic. Just, again, be really careful. Do not agree to waive copayments unless you do it the legal way. Using the phrase soft billing, as I said, just sends shivers down my spine. Please don't do it unless you're doing it legally, and please consult an attorney on the proper way and methods to do that legally. So you may be thinking, yeah, we hire a billing company. This is all the billing company's problem. No, it's not. You, as a commissioner, as a chief, as a village or town board, whoever is the authority and control of that fire department, as well as the operational officers for the ambulance service, you could be personally liable. You could be charged personally, criminally. You don't want to do this. And you cannot say it's the billing company's problem because it's not. It's your problem. And even if the billing company is doing something that you were not aware of, that does not get you off the hook because the law will say, but you should have been aware. Now, at this point, you say, well, how should we have been aware? How should we have known that the billing company was doing something fraudulent? Or let me make it easier, that the billing company was doing something unintentional, but they kept doing it. And as a result, again, a jury's going to say, well, you or the billing company made a pattern of mistakes for a lot of months, a lot of years. At some point, unintentional becomes intentional. You knew or should have known. And if you should have known, you are going to pay that money back times 3, and again, fines, penalties, etc. So, how do we defeat you should have known? Well, if there's anything I can suggest to you from this entire set of modules, this entire number of hours you're watching, it is this. Please audit the ambulance bills after they are submitted. This is not something you rely on your billing company to do. Yes, your billing company may be doing it as well, but it's kind of, self-serving. They're auditing themselves for their compliance purposes. But again, you may get hooked up with a bad billing company who has ulterior motives. I hope you don't, but you may. It's possible. And even if they have good motives, if their audit didn't catch an issue, it's coming back to haunt you. So you need somebody to audit the ambulance bills after they're submitted. And if there is an error, you need to correct it and pay the money back so that you don't get in trouble. How much should you audit? Well, if you're below 1,000 calls, I'm thinking 10%, right? 100 out of every 1,000. That's pretty aggressive, but that also sends a message to the billing company and to the government. Look, we're looking. We want to know. If there's a problem, we want to know. So you will defeat the claim that you should have known if you are looking at 10%. Now, if you're over 1,000, just do 5%. I think that's fine, right? But let me be clear. You're going to do 10% up to 1,000. You're going to do 100 for the first 1,000. After the first 1,000, you'll do 5% of the claims, right? So if you have another 1,000, right? If you do 2,000, you'll bill 100 or audit 100 for the first 1,000, and then 50 for the second 1,000. Hopefully that makes sense. Please, 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 please do not pass over the slide. Please do not pass over this very strong suggestion. Auditing is critical. You do not want to go to jail. You do not want to be fined. You do not want to be embarrassed publicly. You do not want to have to pay a dime back. And you certainly don't want to have to pay $3 back for every dollar you brought in from billing. And let me tell you one other thing. Just defending the claim is very expensive. We do this frequently. It is a very expensive legal bill to defend these claims. because what goes into showing that you didn't know and you could not have known is extensive. But you want to save a lot of money? You put a bunch of audits and right in front of us and say, look, here's all the audits we did. This should go away much easier. So we do these audits. We just want to let you know, we'll be a little self-serving here. We want you to know that the Pinsky Law Group has been auditing departments, ambulance services for a very, very long time. In fact, even in the last 5 years, we've been auditing ambulance companies who've been convicted of fraud, and as part of the government's settlement with them, they had to engage the services of an auditor to review their bills. And we've been doing hundreds and hundreds a month of audits. So we have a very aggressive fee schedule. We audit, again, just as I suggested you, we will do those audits. And we only charge about $1,000 for every 500 calls you run. Now, there could be a little variation if you're ALS, if you're BLS, it could become a little more expensive or not. But if you're interested in having us do your audit services, we'd love to do it. We work with whatever billing company you have to randomly select a number of bills, and then we provide you with the results every month. And obviously, we save all our notes and findings. We will help you improve. We will help the billing company improve, but we will make sure to the best of our ability that you would not lose on the question of you should have known, because we will look so that you did know or should have known, you will know, right? If there's any fraud, any mistakes, even unintentional, just errors, we presumably will catch them by looking. And if we don't catch them, at least you're looking, right? At least you're looking. So let's say the audit didn't send us bill number 2. We looked at bill number 1 and bill number 2 wasn't great, and that's where the error was. You know what? At 10% audit, that's the government says that is more than reasonable to protect you. So we invite you to use our services. Even if you don't use us for anything else, we're more than happy, super happy to work with you on the audits. So we've talked in the past about flat fee and percentage-based billing. It's in a prior module. I just want to talk about it again a little bit now. You are prohibited from using a percentage arrangement where you pay your billing company on a percentage base on what they collect for all Medicaid and Medicare and government programs. But it goes farther than that. The Attorney General and the Office of the Inspector General, right, New York and federal, have given the opinions that use of percentage-based billing is wrought with fraud, is the quote they use. So that's because there's an incentive of the billing company to want to make more, right? If they're getting more on a percentage as opposed to a flat fee, they want to upcharge, and so they get more. So I really don't love percentage-based billing, but that doesn't mean that there's not an advantage of it. Of course there's an advantage, because if the billing company gets more based on the percentage they collect, they also want to work harder for you. So that's something you're going to have to evaluate. But I cannot emphasize enough, if you use percentage-based billing for your non-Medicare and non-Medicaid government claims, you must audit all billed claims. Once they've been billed and gone out, those are the ones you audit, not the ones that are pre-billed, because those can still be changed. So look, you really need to be doing billing audits. But you really, really need to be doing billing audits if you're allowing a percentage-based fee, because the risk is so much higher. Okay, so how do you protect yourself from all this potential fraud or just long-term errors that are going to be interpreted by the government as fraud because you should have known? Enter compliance programs. These have been in existence for, more than a decade, and a billing compliance program, your billing company may have one, right? That's good. You only want to work with a billing company who has a compliance program. Please, if these mom and pops don't have a billing compliance program, don't use them. But you also need your own billing compliance program. This is where we would educate your members on fraud, on the fraud schemes, and tell them not to do it. We would educate everybody who needs to be educated on how to prevent billing. And for example, on the one hand, we would teach you, right? Other attorneys may do differently, but we would teach you how to write reports. At the same time, as we discussed in a prior module, we would not only teach you how to write reports, we would caution you against inflating the reports to engage in fraud, to create medical necessity where it didn't exist, right? We want you to write a good report, but we don't want you to fraudulently write a report. So that's part of our training. And we would train you on what happens to you as well if you violate the law. And you got to know this, right? So if you're a fire district commissioner, you could be held liable, criminally responsible for fraud. If you're the chief, same thing. In the cities and the villages, look, the mayors, the board members, the chief, those who are in charge of the ambulance, you can be convicted and held personally responsible. In the towns, especially if you're operating under the town's ambulance service certificate, the supervisor, the board members, and of course, the ambulance personnel, right? The fire department in this case, could be held personally, criminally, and civilly liable. And the fire company, if you're an independent and you hold the ambulance service certificate or you're engaging in fraud, the executive officers, the directors, the trustees, the chief, the heads of the ambulance, you all can be held personally, criminally, and or civilly liable. So we need you to implement a compliance program. And I'm going to talk about what that does. I have already a little bit. But again, let me emphasize, the reason a compliance program, including audits, which is part of a compliance program, the reason a compliance program is vital is because if you're making a mistake for a year, who says it's a mistake? The jury, potentially, or the government will have to decide, was it a mistake you made for a year? Or since it went on so long and was so repetitive, was it actually something you intended to do? You know, again, the difference between whether it was a mistake and whether it's intentional, that's a jury question. Do you really want to leave that to a jury? Do you want your fate left to a jury? I say no. So what does a compliance program do? Well, first, the federal government said that if you implement a billing compliance program, it's going to protect you if you do it the right way. And these compliance programs are set by federal law. They have to adhere to federal regulations in order to be a good defense. And the ones we do, of course, adhere to the federal regulations. So why would you implement a compliance program? Well, again, I just talked to you. It decides the difference between knew or should have known. Well, obviously, we should have known because we were looking. We were teaching our employees. We were doing all the things we're supposed to do with a compliance program. If you don't conduct billing audits, you're going to be deemed that you could have or should have known. So that's why you want a compliance program. What does a compliance program do? It implements written statements against fraud and abuse saying we are not tolerating it. We're not going to engage it. You do not do it. We're not going to allow it. We're not going to tolerate fraud. That's the environment you want to create. Think of it like sexual harassment training, where you said we are not going to allow sexual harassment. We have a zero tolerance for that, and we're going to teach everybody to recognize it so you don't do it. Same thing with billing fraud. Right? So we're going to require the audits. We're going to educate your employees and your volunteers and your members how to recognize fraud, and we're going to encourage them and we're going to require them to report any good faith suspicion of fraud. Look, if it's a simple error, they'll report it. We'll get it corrected. But if they think it's an ongoing pattern or was intentional and trying to defraud the government or an insurance company, we want them to report it. And I would tell them just this way. We are telling you to report it. In fact, if you knew and you didn't report it, we're coming after you, Mr. or Mrs. Volunteer or employee, right? We want to make sure you know as a volunteer, and as an employee, as a member, your job, your volunteering depends on you adhering to the compliance program rules. So we're going to punish you for not reporting fraud and abuse if you knew. We're going to benefit you in some way if you do make a good faith report and we find it's true. So if you turn it in, we're going to make sure you're protected, you're not retaliated against, but we also may reward you. Why would you reward someone for turning their employer in? Because now you should be afraid of your members, your employees who are looking for fraud, because why? Maybe they wanted a reward for it. Maybe they get a payment, right? If you could do that, we got to work that out as part of the program. Depends whether you're a government, not government, but maybe there's some benefit that they'll get when they report not just an error, but fraud. We want them on our side. We want them always looking. And look, from the government's point of view, the government says, why would anyone engage in fraud and also tell their employees and volunteers, we want you to recognize fraud and find fraud and we'll reward you for doing it? That alone, the fact that we're turning the employees and volunteers into auditors, basically, for fraudulent conduct, that really does protect you. So we're going to discipline anyone. We're going to terminate anyone if they participate knowingly in a fraud scheme. This is all done to protect anyone who could possibly be liable. So you need your own compliance program. As I said, do not rely on the fact that a good billing company will have one, yes, but you need your own. The billing company's theirs. You need your own compliance program. So I hope you learned how to protect yourself and your members and your organization and ultimately the taxpayers in this module. If you need our services, we would love to work with you, working to develop compliance programs or doing the audits or anything you need. And again, as we say at the end of any module, if this caused you to have some problems, please send us questions and we will add them to an 8th module and answer, as we're going to keep on doing throughout the year. We're going to keep answering your questions, especially as updates come out on these laws or changes come out to the laws. We're going to make sure we keep you right on top of things. Well, I'm Brad Pinsky for Pinsky Law Presents, and we will see you at Module 6.